Good morning. Thanks for joining us today for part one of our two-part series focused on leaves of absence. Today we will focus on medical leaves of absence. There are so many laws that affect medical leaves. My name is Denise Keddy and I'm your moderator for this session. A few quick housekeeping notes before I introduce today's expert panel. Our webinar will run approximately 60 minutes in total. Please take a moment now to visit the handouts area on your dashboard to download a copy of today's presentation. If you have any questions during the presentation, you can post them in the Q&A area on the dashboard at any time during the presentation. If you would like your question directed to a specific panelist, you can note that when sending in your question. If you have any issues during the presentation, please email me directly at denisemkeddy@gmail.com. Just a reminder, today's webinar is being recorded and all accompanying materials are protected by copyright. Our presentation today provides general information and does not constitute legal advice. The information that is offered during the webinar is as of today, January 17th, 2019. And as always, we recommend you consult with your own legal counsel to discuss and address specific situations, as they will have the most current information on legal matters. Let's get into our session today. Today we are joined by our legal expert, Kurtis Urien. Kurtis is an associate at the law firm of Merhab, Robinson, Jackson, and Clarkson in the transactional department, where he advises clients in real estate, finance, business succession planning, corporate, and employment law. In addition to his work at the firm, Kurtis has contributed articles to law journals and is a part-time lecturer and teaches classes on economics and conscious capitalism in addition to business law. Kurtis has been recognized by superlawyers.com as a rising star in California for the years 2017, 2018, and as of this morning, he just found out that he is also going to be recognized in 2019. Congratulations, Kurtis. That's an awesome achievement. Our human capital expert today is Linda Duffy, president of Ethos Human Capital Solutions. Linda and her team are known for building the magic of human connection with their consulting, recruiting, training, and also payroll support programs. The Ethos team works with your company by developing strategies for business leaders to get the right systems, people, and culture in place within your organization so that you as a business owner can focus on running your business and achieving your goals. Linda's clients range from high-tech businesses to manufacturing firms to nonprofit, and she is extremely well-versed in addressing the concerns of founder, CEO-led businesses. Linda, can you get us started this morning?
I can. Thank you, Denise. Happy New Year. Thanks for joining us. And Kurtis, congratulations. Well-deserved. So that's exciting news. We'll have to update that slide for future reference. Here's our agenda for today. As Denise mentioned, we're going to focus on the medical leave today. These are usually the ones that we deal with most commonly. And then next month, and we'll show you that date at the end and how you can register for that, we'll focus on all the other leaves in California, which is another like 18, no lie. So these are the ones we're going to focus on today. You'll see at the end there, we always have our Q&A, but right before that, we have common questions. Kurtis and I know the common questions we get from our clients. And in fact, we had one very smart person on the webinar today actually email us a question ahead of time, and it's a really common situation we get. So we're going to address, I think we have 3 common situations and discuss those just before you have a chance to ask some additional questions. So hopefully we're going to answer your questions as we go through, but as always, like Denise said, just go ahead and type it into the question bar on the side, and then if we don't get to it today, we can always circle back with you. So the easiest way that we've come up with to sort of share these leaves with everybody is to take a look at some standard things that apply across the board to all the leaves. So, is the company required to provide this particular leave? Like, who's affected? Because you have 2 issues you have to always look at. Is the company even subject to the leave? And for most of these, that's based on mostly the number of employees, the headcount you have. And then the secondary question is, even if the company is subject to the leave, is the employee eligible for leave? And a lot of times that has to do with service requirements, or is the event in question a qualifying event? Then the question, of course, how much leave must the company provide? The job protection aspect is always a key thing. Must I reinstate the employee when they come back? If I do I have to put them in the same job? Should it be a similar job? All of those questions. Does the employee have to give me notice? And if so, how much? Can the company force the employee to use vacation or sick? And then how does the leave affect the rest of the employee's benefits? So that's how we sort of frame this today. And we're going to hopefully talk about some examples as we go through here to make this clear to everybody. Wanted to point out a couple of things. You know, these slides, as always, because I put them together, are very, you know, they have a lot of information on them. And so I used a lot of abbreviations this time. So if you see ER in caps, that represents employer, EE represents employee, just so everybody's clear. And then I also wanted to put just a quick cheat sheet for everybody on the different leaves we're talking about and how they get abbreviated. And then also we had a request from some people that we needed to be more specific about what applies to employees outside of California, because we have some listeners that are only subject to federal law or maybe their states. So that's the other thing. Just know that we're talking about the ADA and FMLA today, which are federal. All the rest are very specific to California. So with that, let's get into FMLA. So Family Medical Leave Act, you know, has been around for a while now, and this affects companies that employ 50 or more employees. And there's a very specific definition for that in terms of how you count employees, and for how many weeks you count employees and things like that. So if you employ 50 or more employees for each working day during each of the 20 or more calendar work weeks in the current or preceding calendar year, doesn't have to be consecutive, but if you have 50 or more employees in 20 work weeks during this year or last year, you are subject to this. So sometimes I think my clients think, oh, I'm going to stay right below that, you know, 50 mark, and they may be able to do that. But if they, for 20 weeks, go above that, you know, go above 49, then they're going to be subject to FMLA, even if they dip back down. And that's something I think that people aren't sensitive to. You're also going to count any full-time or part-time employee whose name appears on the payroll in a calendar week, because that's even if they don't get compensation during the week. So if they are, you know, on your head count, if there's a reasonable expectation that they're going to return to work, so if maybe they're on a leave of absence, you still have to count them in your head count. The other thing to note is that temps from a temp agency most likely need to be counted as well. So sometimes you may have a situation where maybe you have 45 regular employees and you say, oh, you know what, I'm going to stay below that 50 mark by bringing in those 10 temps. And under the joint employer doctrine, those 10 temps, if they're working for you, are most likely need to be included in this head count. So you may not be able to get around it that easily. So as far as covered employers go, that's what you have to look at is, do you have 50 employees in a 75-mile radius? And if so, the business is subject to FMLA. As far as eligibility for employees go, obviously you need to work for an employer that's subject to it. And then you have to satisfy 3 standards. The first one is 1,250 hours of service in 12 months prior to the leave. 12 months of service with the company, and that does not have to be consecutive, and then work at a facility with 50 or more employees, obviously. And then for FMLA, it covers these 5 areas: birth of a child, placement, care for a serious ill child, spouse, or parent, their own serious health condition, which is what we're going to focus on today, and then military family leave. The other thing to keep in mind is you may have a situation where maybe you have outside salespeople reporting into a headquarters that has 50 or more employees. If that's the case, but they maybe work out of their house and they're not within that 75-mile radius, if they report into the headquarters, they should still be considered covered by this. If they work in a small sales office someplace, like maybe you're based in Irvine and you have a sales office in Bakersfield, then the Bakersfield office has fewer than 50 employees, that office would not be covered. But if there's one person in Bakersfield reporting into Irvine, that person would be covered. So hopefully that makes sense. A couple things I wanted to mention about FMLA. One of the things we always tell our clients is you always go by what the doctor says, right? This isn't up to you to determine whether or not this person has a serious medical condition. It's up to their healthcare provider. And I say doctor, but that actually is an expanded definition to other types of practitioners. So there is a document that you can use. You can use it for anything, not just FMLA, but Department of Labor publishes it specific for certification by a healthcare provider. Again, this is for an employee's serious health condition. There are other ones that are designed if you're trying to get certified for a family member and things like that. So you'll see at the top, you know, the WH380E is the number on the document. One thing to note on here is that there's a question on this form that is actually allowed at the federal level, but not in California, and it's question 4. In California, you need to remove the word diagnosis, and you can download the PDF and actually type into it, and you can actually go right there, put your cursor there, and just delete the word diagnosis. But in California, we're not allowed to ask for diagnosis, so you need to make sure if you are going to use this form to get that certification that you want to remove that word. The other thing is this, employees by law have 15 days to return this. So we use the form a lot when we want greater specificity than maybe what a doctor's note says. Maybe we want to engage in that interactive process and the doctor says, oh, the person can't work. But we go, you know what, like based on what we see, you know, maybe we need to get some greater specification to see if we could offer that person some sort of reasonable accommodation, or maybe we could change their job and allow them to continue to work. And that's sometimes when we use this certification form. So going on with FMLA, the length of leave available is 12 weeks in a 12-month period. There's different ways that you can calculate that 12-week period. So you can go by calendar year, any 12-month fixed leave year. You could do it based on, you know, a fiscal year, the employer's anniversary year, anything like that. You can also take the 12-month period measured forward from when FMLA leave is first taken, or a rolling 12-month period measured backwards. There's a whole bunch of different ways to do it. You just want to pick one and just sort of stick with that. FMLA is definitely job protected. There's one exception to that rule, and that has to do with key employees. We're not going to go into a lot of detail about that, but if the person is a key employee and there's a definition having to do with the top 10% of your compensated workforce, then you may be able to refuse to reinstate them. If your employee needs a leave of absence, they need to give you 30 days notice if it's foreseeable. There's some types of leave, obviously, that are. If you're outside of California, for example, and you're pregnant, then clearly you would know. FMLA doesn't cover California employees for pregnancy, but as just an example, you know that that's coming. If it's a planned surgery ahead of time, then you would know that that's coming. A lot of times, though, if it's your own serious health condition, you don't know. Something happens, you're in a car accident, you get sick, something the doctor says you're going to take time off. If the employee does not give 30 days notice and it was a foreseeable illness or injury and they need the time off, then at that point you can delay it for 30 days, but just be really careful before doing that. The other thing to know about this is I've had clients say, well, they never put it in writing, or you know, they didn't tell me they needed FMLA specifically, and that's not the rule. The rule is that the employer has the burden of advising the employee when they know that there's a circumstance that triggers FMLA, that they are entitled to FMLA. There are other requirements in terms of posters. You also have an eligibility notice that you're required to give the employee within 5 business days of that initial request for leave, or when the employer finds out that the employee may have an FMLA qualifying event. So if you're talking to an employee and the employee says, yeah, I'm going to need surgery, and you know that as an employer you're covered by FMLA, then you need to then do the analysis of whether or not the employee is eligible based on their own situation and meeting that eligibility criteria. You need to give them this notice. And it doesn't have to be in writing, this one, but as far as I'm concerned, you should be, because you want to have documentation you provided it. And if you're going to give it to them, make sure you give it to them in a language that they understand. But what I would do is give this to them right away. If you do the analysis and they're not eligible for FMLA, for whatever reason, it's not a qualifying event, or they don't have the eligibility requirements, then you need to tell them why they are not eligible for FMLA, and then look to see if they're eligible under any other company policy. At the same time you give them the eligibility notice, you need to provide them with a rights and responsibility notice. I used to always call this a designation notice. Department of Labor calls this a rights and responsibilities notice. I don't know when it changed, but that's what's on their website now. So there's a long list of things that you need to include in that notice, and they're pretty straightforward. And I like the actual title, Rights and Responsibilities, because you want to tell the employee what their rights are, but they also have responsibilities. They have obligations to the company in terms of, you know, making premium payments to maintain their health insurance, things like that. You might have some requirements in terms of when, you know, notice requirements to you when they're ready to come back. You want to tell them that they're going to have to get a doctor's release saying that they're physically able to perform the essential job functions when they come back. So there's a whole long list here you guys can read for yourself, so I'm going to move on to this. FMLA, can the employer require use of sick and vacation? Here's how I generally think about this for all of these leaves, and then I'll leave it to you to read what's on the screen each time. As I think about sick and vacation like this, employers can generally require the use of sick if the absence is due to the employee's own medical condition. So if the employee comes to you and says, you know, I need surgery, then yes, you can force sick, okay? If they come to you and say, I need time off to take care of somebody else or some other non-personal medical condition, then you can't force the use of sick, but you can force the use of vacation, okay? If you combine the two together, then you have to be careful because you have to always go by the higher standard. So you may not be able to force anything if it's PTO. So you always want to check on that. When somebody takes an FMLA leave, then the benefits are required to remain in place as though the employee had not taken leave. So in this case, we're talking specifically about group health insurance. And so if somebody is going on an FMLA leave, you cannot put them on COBRA, you cannot cancel their insurance unless they fail to make their payments. So you want to work with the employee and let them know in that rights and responsibilities notice how much they owe, the part that would normally come out of their paycheck, and how should it be paid to you. So send a check, you know, no later than the 15th of no later than the 15th of every month to such and such in the amount of this, right? Or sometimes you might suggest to them that they double up on payments for like the month before they go out or something like that. Or if it's okay with the company, you can let them pay it back after they come back. So they just won't have a paycheck typically. Sometimes people will take it out of vacation or sick if they're using that. So just have that conversation with the employee and figure out the best way to handle that. Okay, the second law that comes into play is specific to California, and that's the California Family Rights Act. CFRA is almost identical to FMLA with a couple of exceptions. One has to do with military family leave, which we're not going to talk about today. The huge one, though, and this gets sort of confusing, is pregnancy is carved out. So I think I misspoke earlier when I said FMLA doesn't cover pregnancy. It does. CFRA doesn't cover pregnancy in California, so my mistake on that. So under CFRA, if a woman becomes pregnant in California, it's not triggered. CFRA is not triggered because we have a special law for pregnancy in California. It does trigger FMLA. Okay, so sorry if I confused anybody before. The length of leave available is the same except for service members. It's still job protected. Still have to give 30 days notice if it's foreseeable. And then you want to make sure that you're using those written designation notices and doing the same thing. Just mention CFRA in addition to FMLA when it applies. The same requirement is that you respond to the employee's request as soon as practicable, but no later than 5 business days after the request. So you're going to want to make sure that you stay on top of this whenever somebody comes to you or you find out they might have a need for the leave. Same thing about vacation and sick, and then also same thing about the effect on benefits. California is actually a little bit more expansive as always, so they're entitled to accrual of seniority and other benefit plans that FMLA doesn't mention. So you just want to make sure that you always seek some counsel on this and make sure you don't cut off anybody's benefit while they're on a leave. Okay, so as I mentioned, in California, we have a special pregnancy disability leave law, PDL for short. This covers employers with 5 or more employees. So almost all of our clients are covered by this. Eligible employees are when you have a pregnancy-related disability. And I underline that and bold-faced it because this is a mistake that a lot of employees make, a lot of employers make. I get calls all the time where somebody says to me, well, I'm pregnant, so I get 4 months off. And that's not the case. You get up to 4 months or 17 1/3 weeks off for the period that you're disabled due to pregnancy. Okay, so that's a really key distinction. So you have to be disabled due to pregnancy. You don't just get it because you're pregnant, and you don't get it because you want 4 months off to bond with your baby. It's while you're disabled due to pregnancy, and we'll talk about baby bonding in a second and show you a chart on this. There's no length of service requirement, and we have a scenario for that we're going to address later. So, you know, from the day that a woman starts at the company, she doesn't have to be there for a year, have 1,250 hours like on the FMLA and CFRA, no length of service requirement. If she's pregnant, she's covered by this law. As I mentioned, up to 4 months, which is 17 1/3 weeks. Job protected, yes, there are some very isolated exceptions that Kurtis and I will tell you don't go there. And notice is required, which obviously everybody pretty much gets notice on that one. Responding to the request for PDL, you have 10 days to do that. But remember, if the woman is subject to FMLA, then you want to make sure that you're going by the 5-day rule, okay? And then again, once we talk about baby bonding, again, designated and under CFRA for 5 days. You can force the use of sick. You cannot force the use of vacation or PTO. And of course, you can always offer them the opportunity to use either. In our experience, most of the time people, you know, women that want to use it or anybody going on a leave wants to use any available sick or vacation time to supplement their, you know, SDI benefits or for the week waiting period or whatever it is. Okay. And then again, you're required to leave the group health benefits in place. So here's a chart that we made for leaves that run concurrently for pregnancy. So somebody goes out on pregnancy disability leave February 1st. FMLA is going to run for up to 12 weeks. PDL is going to run up to 17 1/3 weeks. While the person is disabled due to pregnancy, right? Let's say they exhaust that 17 1/3 weeks, right? They're not subject to CFRA. But if somebody, let's say, you know, for most normal pregnancies, it's 4 weeks before and 6 weeks after childbirth. So that's 10 weeks that they might be disabled due to pregnancy, right? But that would still give them 2 weeks under FMLA and another 12 weeks under CFRA for baby bonding purposes, right? So this can play out a lot of different ways, but we just wanted to be clear that CFRA does not run concurrently with pregnancy disability leave. All right, and with that, I am turning it over to Kurtis so he can talk about the next couple of things. Kurtis.
Thank you, Linda, and thank you, Denise, for the introduction. So our next topic is the Americans with Disabilities Act, or we have abbreviated as ADA. Now, the Americans with Disabilities Act is a federal law, and it applies to all 50 states. We've talked about some California-specific laws here, but the ADA will apply to all 50 states, even to employers here in California, even though we have other laws that we deal with. The ADA applies to employers with 15 or more employees. All employees with qualifying disabilities are eligible for ADA, an ADA leave of absence. And the qualifying events are disabled employees who need time off as a form of a reasonable accommodation. Now, technically, there are some differences between the federal law definition of disability and the California FEHA definition of disability, but the differences are very nuanced and are probably not going to make too much of a difference from the employer's perspective. But if you ever have a question on it, feel free to give me or Linda a call and we can work you through it. The length of leave under the ADA is not specified. We saw in FMLA that the maximum amount of leave that can be taken in a year is 12 weeks. We saw CFRA is the same, 12 weeks. And we saw that pregnancy disability leave is 4 months or 17 1/3 weeks. But as you see here under the ADA, there is no maximum amount of leave provided by the law. You could have situations where an employee is entitled to 1 day of a leave of absence under the ADA, or an employee is entitled to many months of a leave of absence. And we're going to get into that a little bit more here and when we talk about FEHA. Is the job protected when the employee returns from an ADA medical leave of absence? Generally, yes, but there are some situations, there are some exceptions where an employee does not need to be reinstated. And if you ever have a question or if you ever choose or if you're ever leaning towards not reinstating an employee, our recommendation is to give us a call. We can walk you through that process. And notice is required by the employee, a request for a leave of absence under the ADA. Don't want to talk about ADA too much because most of our attendees here are in California. And in California, we have the Fair Employment and Housing Act. The Fair Employment and Housing Act, or FEHA, is the California version of the ADA, but FEHA expands on the ADA and has quite a bit more restrictions and gives employees a whole lot more rights than the ADA does. And as a general rule, whenever there's a federal law and a state law that govern the same topic, you want to follow and comply with whichever law is more restrictive or more expansive. And so for employers here in California, we will mostly deal with FEHA. Now, FEHA applies to employers with 5 or more employees. The eligibility requirements are basically the same as the ADA, and the qualifying events are basically the same as the ADA. All employees are eligible, and it's for any disability or medical condition. And like I said, the definition of a disability in California is a little more broad than it is under the ADA. But if you ever have a question or ever have a problem figuring out whether a disability or a medical condition is covered, just give us a call. We can walk you through that. Again, just like the ADA, FEHA does not have a specific length of time. It could be one day, it could be many months. It just depends on the circumstances. Jobs are protected under the ADA. There are similar exceptions under FEHA. And generally, yes, notice is required by the employee to take a leave of absence under FEHA. However, the FEHA goes a little bit further and says that if an employer perceives that an employee has a disability or medical condition, the obligation to engage in the good faith interactive process is triggered once you perceive an employee has a disability. So even though an employee is required to provide notice of a request for a leave of absence, in California, if an employer perceives that employee may need a leave of absence, the employer has to start the conversation. Like I said before, there are a lot of similarities between the ADA and FMLA. I'm sorry. I said before, ADA and FEHA have a lot of similarities, but there are some similarities between the ADA and FMLA. There are some definitions that are similar and some definitions that are not similar. For example, some serious health conditions may be ADA disabilities, but other conditions may not be ADA disabilities, even though they're protected by FEHA. All right, next we're going to talk about workers' compensation leave. And we're going to get back to some of the disability leaves here in a second, but we just wanted to hurry up and get through workers' comp leave here first. So workers' compensation leave applies to all employers, all California employers, regardless of the number of employees. So as soon as you get one employee, that employee is covered by the workers' comp leave laws. And it doesn't matter how long the employee has been there, there are no eligibility requirements for that employee. The fact that you have an employee creates rights under the workers' compensation leave laws. And qualifying events, any kind of industrial injury, so any kind of work-related injury or illness can trigger rights under the compensation leave laws. Similar to ADA and FEHA, there's no length. There's no specific length under the statute. It's for workers' comp leave. It's for the duration of the injury. What we really want to emphasize is that you get workers' compensation insurance when an employee is injured, you give them the notice of a claim form, the DWC-1 form, as soon as possible, that same day. The good thing about having workers' comp insurance is when an employee gets injured, an adjuster will be assigned to the case and can help walk you through what your requirements are for workers' comp leave. When an employee comes back from workers' comp leave, they do have reinstatement rights, but if you terminate an employee who makes a claim of a workers' compensation injury, or if you terminate an employee coming back from workers' comp leave, then you could be subject to a discrimination claim under Labor Code Section 132A. And as you can see here, workers' comp leave can run concurrent with all other forms of leaves of absence. And there's no limit to the amount of time for a workers' comp leave. All right, so I want to finish up here by talking about the interactive process. So when an employee comes to you and says, I'm sick, I'm injured, I'm getting surgery, I need a leave of absence, the law says, both under the ADA and FEHA, that the employer engages in the timely, good faith interactive process. And I get a lot of questions. Well, what does that mean? Well, unfortunately, the legislature didn't really give us a good definition for the timely, good faith interactive process, but the courts have interpreted this requirement and have given us some insight. So we know that the employer must engage in a timely, good faith interactive process with an employee or applicant with a known physical or mental disability or known medical condition. So if we break up this requirement into its components parts, we have timely, good faith, interactive, and process. Timely meaning as soon as you get a request from an employee, as soon as you perceive that employee has a disability, don't wait around. Engage in that process as soon as you can. Have that open conversation with the employee. Good faith, what does this mean? Well, good faith means that you actually have an honest, open, an actual conversation with the employee, actually engage in the process in figuring out what accommodations can be made. And interactive meaning that all parties are involved in the process. The employer, the manager, supervisor, the employee, the healthcare provider, everyone is involved in the collaborative process to determine if a leave of absence is a reasonable accommodation. And it's a process, it's an ongoing effort. It's a collaborative, ongoing effort. If you just summarily deny a medical leave of absence request, you're probably going to get sued. It's an ongoing process to figure out what's available, what can be done. And it's not just an obligation for the employer. The employee has an obligation to engage in the process as well. Typically, an employee must be able to provide the employer with a list of restrictions or a request for a medical leave of absence. And it's then the employer's job to take those demands into consideration. And always, always, always document everything. Document the request, document the observation or the perception of a need for an accommodation. Document conversations, document phone calls, take notes. Documents, documents, documents. And if you have any more questions on the interactive process, or if you ever have a specific situation and you're not quite sure what to do in that interactive process, feel free to give me or Linda a call. We're happy to help you out. So that's all we're going to share in the interactive process. And at this point, I'm going to hand it back to Linda.
Thanks so much, Kurtis. Sorry to fast forward on that slide. I actually lost you for a second. I thought you'd stopped talking, but I think it was on my end. So that was a lot of information. I know crammed in a really short period of time. There are a ton of resources, though, available besides me and Kurtis, so we wanted to point those out too as well. So, at the federal level for FMLA, the Department of Labor publishes resources. They have FAQs, they have fact sheets, they have sample forms and posters. One of the things I didn't mention on any of these is almost all of these laws have some sort of notice requirement, whether it's a posting requirement or some sort of written notice requirement or both. So you want to make sure that you know what posters you have and update those each year. There's a general FMLA page you can go to. There's also a general ADA page you can go to at the federal level. DFEH has similar resources for the laws in California. I wanted to spend a little time talking about JAN, or the Job Accommodation Network. I don't know how many people have used this before, but I've used it on a couple of occasions, and I find it really helpful. It is a public service, and it's just like it sounds like it would be. There are people there that can give you advice on how to accommodate somebody that has some sort of disability. So I've used it on a couple of occasions. One was with a company where it was very computer intensive. There was an employee who had a degenerative eye disease, and his job was basically to spend time reviewing forms online all day long, via email, based on the web as well. And so the problem was his productivity was really suffering and his quality was really suffering. And then he announces, oh, I have this degenerative eye disease. So we engaged in an interactive process, but at the same time we were talking with him, we called Jan, and we talked to Jan and we said, help us understand what might be a reasonable accommodation. And more importantly, this goes back a number of years, but more importantly, do we have to make any sort of accommodation for him in terms of productivity or quality? And they said, absolutely not, right? And that's a really important thing to keep in mind. So even if somebody has some sort of disability, that doesn't mean that you have to lower the productivity standards or excuse errors in work or anything like that. But what it does mean is you need to, throughout that interactive process, figure out what could be a reasonable accommodation. Keeping in mind, of course, what's reasonable for Boeing is not reasonable for, my employer that's got 10 employees. So when we asked them and we talked to the employee, one of the things that we came up with was getting him a special type of computer screen, a much larger computer screen. So for an investment of a few $100s, he was able to continue to do his job. Another example when we called Jan was with another client of mine that has generally an office environment, and one of their employees had a knee injury. They thought she was going to have surgery. Her job was upstairs, and they're in a building that doesn't have an elevator. So they accommodated her originally by moving her downstairs, but then she's an accounting person sitting in the engineering department, and the engineers need the space because they're going to hire somebody. So they wanted to kick her out and essentially came to me and said, can we fire her because she can't walk up the stairs? And I was like, not so fast. That's probably not the best approach, but let's talk about this. And we got on the phone with Jan to say, what ideas do you have for what would be a reasonable accommodation? And so we looked at different things, because it's not reasonable to expect this employer to build an elevator in their building. But, they had two different staircases. And one of the things Jan said is, what about one of those, chair lifts that you see on TV or the infomercials all the time, right? Maybe one of those. Maybe you allow her to continue to work downstairs. You find new space for her, something like that. So they can be pretty resourceful, and I find that to be really useful when you're going through the interactive process. Like Kurtis said, it's really important to understand, what could you do? And I always tell my clients, if this was your best friend, right, and you're fully invested in their success, what would you be willing to do for them? And sometimes if you, think about it from that standpoint, you come up with some pretty creative solutions. So those are some resources you can check out. Okay, we thought before we get to your questions, we would discuss probably the three most common situations that come up in some form or other. And I've already seen a couple of people type in questions that are similar to these. So let's go through these. But while we're doing this, if you do have a specific question that we haven't addressed, by all means, type it into the question panel. Denise is looking at those, and then she'll ask us some additional questions. So Kurtis, let's talk about these. The first one, I just hired an employee, and on day one, she announced she's pregnant. Can I fire her because she's in her introductory period? What say you, O wise one?
Amazingly enough, I get this question fairly frequently. I'm used to it by now. I'm used to how often I get this question. But when I tell my friends or family how often I get this question, they're blown away. But this is an actual question I get very often. And the answer is, well, most likely not. Just because the employee didn't tell you she was pregnant during the application or interview or hiring process doesn't mean that you can fire her once you find out that she is pregnant. She has rights as a pregnant mother to have her job, to not be discriminated against just because she's pregnant.
Right.
Now, I have heard some situations, and I've dealt with some situations where there's a pregnant employee who didn't tell the employer during the hiring process, but then during the first few months she has a problem with performance doing the essential job functions, and and the performance is completely unrelated to the pregnancy. And those are situations where maybe, you might need to let the employee go because she can't do the job, and it's completely disconnected from her pregnancy. But this is it is a sensitive subject as society. We want to have babies and further our species, but at the same time, we want people to have jobs and do work. So there's definitely a balancing act that we have to go through.
Yeah, and I'm more of a smartass than Kurtis. So my answer when a client asks me this is, you can fire her. Just get out your checkbook, because you're going to be writing a hefty check when she sues you and she wins.
Yep.
So yeah, you definitely don't want to fire somebody in this situation. And we didn't really talk about terminations. One comment I'll just make in general, to follow on to what Kurtis already said, is with all of these leaves, when there's job protection, there are circumstances under which you might be able to let somebody go, but they're rare, and you want to be super careful about it. So, for example, I've had situations where maybe somebody's out on a pregnancy leave or an FMLA leave or something like that, and the entire department that they're in gets outsourced or something like that, or the business gets sold or something happens. If their job would have been affected had they been at work, then it's probably okay to allow it to be affected even though they're out on a leave. You just want to be really careful. And where it usually comes up for us is, I've got 5 employees. I need to reduce by 2. Can I let the woman that's on pregnancy leave go as one of those 2? Okay. And again, my answer would be the same: get out your checkbook. Okay.
Yeah, probably not.
Probably not, right? So again, you could look, because maybe she's had 10 written warnings before, she went on a pregnancy leave. There's a lot of other circumstances you want to take a look at, but that's definitely when you want to get your attorney involved in those conversations. All right, so the second one, my company isn't subject to FMLA CFRA because I'm a small employer with 15 people. One employee has a non-work-related medical condition that requires surgery, and her doctor says she will need 10 weeks time off. Do I have to give her a leave of absence?
Well, so
Kurtis?
My answer for this one really isn't straightforward. I would if a client asked me this question, I would come back and say, well, you have to engage in the timely, good faith interactive process to determine whether a leave of absence is a reasonable accommodation, and whether this requested accommodation of a leave of absence would impose an undue hardship on the company. Majority of the time, more often than not, a leave of absence in this situation is usually reasonable, and I would probably recommend granting the leave of absence under ADA or FEHA. But again, my first response is to engage in that good faith interactive process to figure out what's the situation, what are the circumstances, what effect is this leave of absence going to have on me? Can I find a temporary replacement? Can I spread the duties around? It's a process, and it's ongoing, and it's collaborative.
Yeah, I definitely agree with that. And especially for employers in California, FEHA doesn't specifically grant time off like FMLA does or CFRA does, but it does say that giving time off may be a reasonable accommodation. So going through that interactive process is really important. The other thing I would say is what is the harm in giving her a leave of absence, right? So why not just put her on a non-job protected leave of absence, right? Because you could do that. And if you need to fill the position because it's a business need, then fill the position. If that's what you need to do, document why you can't have a temp fill in, why you can't just suck it up among coworkers for a period of time. It is going to depend on the job. And then when she gets released to return to work, look around and say, do I have a job for her? And if you don't have a job, then let her go at that time if that's what you're going to do. Again, I would suggest you get one of us involved with that decision. But I would definitely give her the leave of absence up front. What I would not do is say, oh, you need surgery, you need 10 weeks off. I'm sorry, I can't give you a leave of absence. I just think that's asking for trouble unnecessarily, because it's not costing you anything to have her on a leave of absence. Okay, third one, Kurtis, this happens all the time, and I've already seen a couple people write in with questions on this. My employee with diabetes requested 2 months off, then extended it for another month. Now he's asking for another 2 months off. Okay, so we're up to 5 months. Do I have to keep his job open if I have 50 or more employees? What if I have under 50 employees? Can I fire him? You want to break that down for us?
Yeah, so this is a common question that we get. Let's take the situation where there are more than 50 employees. It's a larger employer. And let's say the employee is eligible for FMLA leave. The employee gets 12 weeks under FMLA, so we got the 2 months, we got another month. 12 weeks of FMLA expired, but the employee is saying, hey, I need another 2 months off. What do? Can I fire this person because they've used up all their FMLA leave? And the answer is no. You really probably shouldn't and can't. The answer is when an employee exhausts all of their FMLA leave or all of their PDL leave, the employee is then subject to the requirements and protections of FEHA or the ADA. So when those 12 weeks are up, or when those 17 and a third weeks are up under PDL, you then have to engage in the good faith interactive process to determine whether this leave of absence request is a reasonable accommodation or whether it would impose an undue hardship. And if you've gone the last 3 months being able to grant this leave of absence, then the law is probably going to say that you should be able to continue to grant this leave of absence. So even though an employee exhausts their 12 weeks of FMLA or their 17 and a third weeks of PDL, you then have to engage in the good faith interactive process under FEHA to determine whether the continued accommodation is reasonable. And if it's under 50 employees, and we're not talking about FMLA or PDL, when that employee requests for more time off, you still have that same obligation to engage in the timely good faith interactive process to determine whether that continued leave of absence is reasonable or whether it's an undue hardship. I wanted to mention one other thing here, but I don't remember what it was. Linda, do you have any insight here?
Yeah, let me jump on that while you're talking. Yeah, because this comes up a lot. You know, it gets extended, and then you're sort of like, okay, now we sort of feel trapped. And as Kurtis said, you've been extending for so long. What I want you to do is think about the issues differently, right? One is, you know, do I have a hardship in extending, giving them additional time off? And the answer for that is probably no. There's probably not a lot of cost associated with you unless it has to do with continuing their medical insurance or something like that. And if that's the case, then make sure you write in your policy at some point in time after the, you know, like way down the road, right? Like, you know, maybe for 6 months or something like that, we'll continue to pay the company's portion as long as you pay yours. After that, you're on COBRA, okay? For most leaves, you can do that. That's usually the only cost associated with it. So again, my recommendation would be, and I literally just had this situation come up in a meeting Monday afternoon with a client. They have fewer than 50 employees, and this is their scenario. And I said, just leave him on the leave of absence. There really is no downside to leaving him on the leave of absence. When he comes back, if you don't have a position for him, then we'll deal with it at that time. But to fire him now while he's on his leave, I think is asking for trouble. So that's my feeling on that. The other thing, Kurtis and I wanted to mention, we were both at the same seminar of, you know, I don't know how many months ago, 6 months ago or so, looking at a panel of attorneys who are talking about leaves. And there was somebody that represents employers, somebody that represents plaintiffs, and an in-house counsel. And the woman that represents plaintiffs, meaning she'd be the one suing you, said, please, 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 sarcastically, please say in your designation letter that if you don't return in 12 weeks or 17 or 30 weeks or whatever it is, you may be fired. She's like, I love it when people do that. And it's just because of what Kurtis has been, you know, emphasizing is under FEHA, you may you may be responsible for continuing that leave and extending it and granting additional time off. So don't ever say in your designation notices, if you don't come back in 12 weeks, you will be fired, or we won't have a job for you, or something like that. All right, Denise, do we have some other questions? Do we have 5 or 6 minutes? We can talk about them.
Yeah, sure. A lot of the questions you've covered a little bit, but I want to make sure that the person who typed it in feels that they get their question answered specifically. We have a question. We're a small company, under 50 employees, and currently we have an employee on FMLA for their own serious condition. She took 6 weeks originally, and on the day she was planning to return, she emailed HR with a doctor's note saying they needed to extend the leave for another 4 weeks. If she does that again, asking for an additional 2 weeks, which would mean that she would meet the 12-week maximum, are we able to say that we need her to return, or we will have to fill your position?
Okay, let me start on this and then Kurtis can jump in. If you're a small company under 50 employees, then do not designate this as FMLA. I don't know. I mean, to me, the question is wrong to begin with. Okay, so.
Yeah, they've already made a mistake.
Right, so maybe there's,
as FMLA.
Yeah, so I have reviewed handbooks before for employers that are under 50 where they write FMLA policies, and I'm like, what are you doing? FMLA has very strict requirements around it, right? That if you're under 50 employees, you don't have to comply with. Now, to the meat of the situation, it's sort of like what we were just talking about. I would not say, hey, if you can't come back in 2 weeks, you're fired. I would just go ahead and unless there's a real reason to not give them additional time off, I would extend the leave, right? And then just tell them it's not job protected. And there's been times that maybe you say, okay, you know what? We think that we can cover this for the first month somebody asked for, right? So we're going to go ahead and job protect it because we're good people and we do want you to come back, but then it gets extended. You might have to redesignate it and say, okay, we're going to grant you additional time, but it's no longer job protected, right? That's up to you. But don't designate it as FMLA if you're under 50 employees. Don't designate it as CFRA, okay?
Yeah, and one thing to add on here too is the law, FEHA and ADA, does not require you to grant a request for an indefinite leave of absence. That's not reasonable if an employee says, I need an indefinite leave of absence for my medical condition. You don't have to grant that. That's undue hardship. That's not reasonable. The employee needs to give you a set of time. But what we often see is an employee will take 6 weeks, 8 weeks, and it keeps getting extended, and then it kind of turns into an indefinite leave of absence. Well, in situations like that, you've been accommodating the employee, so it's likely reasonable that you can continue to accommodate the employee. And I get questions often, well, we've been accommodating this indefinite leave of absence and we're kind of sick of it. We want to let this employee go, take them off their books. Can we do that? And my question would in return would be, well, what's changed? What has changed in your situation or circumstances where you need to take this person off your books? And if they say, well, nothing's really changed, we're just sick of dealing with it, then that's probably not a good reason. That's probably going to get you sued.
So one good idea that I've heard of before, and we use this sometimes though, to Kurtis's point, just having some unknown ongoing leave of absence is not reasonable to even Department for Employment and Housing, believe it or not. So one of the things that we have is we designed a letter that we have we send to the employee and have their doctor fill out. And one of the questions on it is, what's the probability or likelihood that this employee is going to be able to perform their essential job functions within the next 90 days? Something like that. Is it 100%, 75%, 50%, 25%, 0%? What is it? And if it comes back like less than 50%, then at that point you may take the approach of, okay, look, if, we would hold this open if they said like, hey, we think they'll be back in, in a 75% likelihood they'll be back in the next, 30, 60, 90 days. But if the doctor says it's not likely, then I think at that point, it's the possibility, right, exists that you could at that point terminate the leave of absence based on the improbability that the person's going to return to work. Denise, other questions?
Yeah, we have quite a few more around the FMLA, but I want to make sure that we cover a couple other ones. So if we don't get back to you on your specific question, we'll make sure that we get back to you after this this afternoon or tomorrow. We have one: if an employee notifies a manager instead of HR about an event that may make them be eligible for FMLA or CFRA, does the 5 business day notice requirement apply to the company from the point at which the employee told his or her manager?
That's a great question. Yes.
That's a
really good question. Yeah, it's a big old yes, because managers are agents of the company. And so, I mean, Kurtis can tell you the legal doctrine. I don't remember the name of it, but yeah, anything a manager does, knows, whatever, it's as though the company knows it. So yes, Lauren, that does matter, and that's where training your managers comes in. Make sure the managers know, what to do, what not to do, right? Don't go up and go, hey, are you pregnant? Like, don't train them not to do things like that. But at the same time, say, hey, I need to let HR know, if you think that there's a need for a leave of absence, or if the manager becomes aware of something.
Great. We had another question come in and says, a shareholder of our company, also who's employed at the company, announced that he was diagnosed with cancer and issued a retirement date. They replaced his position, so someone new was hired. Then on the date of the retirement, the person who previously said that they were going to retire announced they were going to remain on staff. Now the other shareholders are trying to make the employee shareholder honor his original date of retirement. Does this put us at risk?
I think that's a little too specific.
Okay.
Details.
Yeah.
I think
it's too specific, but it's not even really about the leave. Let me just say one thing real quickly about this, and then I would say whoever wrote that question, give Kurtis a call. What I would say is this: anytime an employee offers their resignation, accept it. That's what I'll say. Accept
Don't wait.
Yeah, don't wait, right? Because this does happen, not even with this fact pattern. It just happens in general, where they give their notice because they think they're starting the job, the other job falls through, and then all of a sudden they want to keep their old job or whatever it is. Keep the power to you, right, by accepting their resignation, right? So I would say whoever asked that question, give Kurtis a call so you can go through that one. But that's less about the FMLA and the cancer and so. All right, I think that's about all we're going to have time for, Denise.
Yeah.
Like I said, quick ones.
No, I think they're going to be pretty involved because they go back to questions that you guys talked about earlier today. So like I said, we'll get back to you. But thanks for the questions. We do have a lot of questions coming in today.
Good. And I know I saw one question pop up. We didn't talk about this. All of these leaves are unpaid by the company. So somebody asked about money. So when I'm coaching my clients, I always say you have to think about time off separate from money. So the first question is this person eligible for time off under any policy, under any law, under anything, right? And if so, you deal with the time off. And then secondarily, is there a way to get this employee paid for this? The company is not responsible for paying for any of these leaves. There are 2 we're going to talk about next month. I'll use that as a little teaser. 2 we're going to talk about next month where they may be required to pay, but there is state assistance available through, state disability insurance or paid family leave or whatever it is for a lot of different leaves. So thank you so much for joining us. And again, thanks, Kurtis, for stepping in. The next webinar is actually on Valentine's Day. So will you all be my Valentine on February 14th, 11 a.m., where we're going to talk about part 2, which is all of the other leaves we have in California. And you see the registration link, and you'll get a notice from us as well on that. So thank you all so much for joining us, and we look forward to seeing you next month.